I can't hear you, Tamar. Mic check. Mike. Can you guys hear me?
Sure, we can.
Awesome.
I don't know. Can y'all hear me?
Yeah, we can now.
Okay, there we go. I'm sorry. I've been like, what's going on with my phone? Hey, Jeremy.
Hey.
What's going on? Thank you all for coming. So we got more folks joining the call now. Shout out Edwin, right on Edwin. Good to see you, brother. Tony, good to see you as well. I'm excited, Jeremy. So let me get my notes together. Hold on, let me get my notes. So essentially, if you guys have been with us these past several weeks, we've been, trying to get some information out there for adjusters to, help them get started in their career. And part of that was to actually get the information, workers' comp being one of them. We want to, provide some crop knowledge, some auto knowledge. So this one is actually one that I'm excited about to add on to what we learned last week. So I don't know, Tamar, you want to take it over? You want to do the housekeeping? I don't know how you want to do it. So,
well, real quick, we do have Mr. Jeremy Lunn here tonight. He is I know I'm so excited. He is a Texas workers' comp adjuster attorney, and I may be getting the whole title incorrect, but I know he's going to fix it. But for any of you all who are Texas licensed adjusters, tonight's Zoom, you will get credit. You will get credits, continuing education credit for this, for workers' comp. So that's good news. So at the end of this, we will go over how you can get your CE credits. We're going to send out the information. So be sure to put your email address in the chat so that we can get the information to you to get your credit.
Woo!
And introduce Mr. Jeremy Lunn. Welcome, Jeremy.
Let's see. You guys ready to? It's 7 o'clock. You guys ready to get going on this?
Let's do it.
Okay. Cool. Well, just so you know, my name is Jeremy Lunn. I'm an attorney in Dallas, Texas, with the Silver. I've been doing Texas workers' comp since I came out of law school. I mean, literally, it's like been almost my entire career. So, and I would say it's about 85% of my practice. I do this a lot. I'm a professor for the state bar here in the great state of Texas. I'm the one that puts together the organizations for the attorneys, basically this continuing legal education for the attorneys to do. Plus, I train up a lot of the adjusters in a lot of the various third-party administrators here in Texas. So, anyway, I guess as we're starting out, let me just first off say, if you guys have any questions, you just want to just jump in and ask a question. That's totally good. If you want to, a lot of times I start asking. I can't help myself. I tend to ask questions during my seminars. So as I'm doing that, it just feel free just to unmute and give an answer whatever you think the best answer is.
Okay. All right. So 2 quick questions. Is it okay if we record it?
Sure.
Okay. And did you want to present your slides, or you want me to?
Oh, you have the slide. Do you have the slides there electronically?
Uh-huh.
Yeah. You can control the slides because I don't know if I have access to that.
Okay.
Let me take a look here.
Well, I can.
If you have the slides, put them in there. If you want to, I can.
Yeah, I can give you control.
And that way I can kind of go along with the slides as well. There you go. There are the slides. That's perfect. Okay. So again, there's my number. So perfect with the Silver Affirmative again, Jeremy Lunn. What if I just hit spacebar here? It should go on to the next one. You think? Let's see.
I think that muted you, Jeremy.
Oh, sorry. So let me see. How do I move? Oh, there I go. Okay, it slides. Okay, good deal. Okay, well, ultimately, for those of you who are, I guess we have all different levels of adjusters here. Maybe I'm not sure. A lot of them entry-level adjusters. So let me start off and say, first and foremost, working as an adjuster and working as an attorney are very, very similar jobs. Much more similar than you might believe. It's very, very common for my senior adjusters to call up and frankly hash it out with me on a daily basis over issues that are coming up and specifically, fact patterns, things like that are throwing people for loops. we bounce ideas off one another. I bounce ideas off adjusters. They bounce ideas back off of me. So that's how it works. I would say that as an adjuster, that's about the closest job I can think of to actually being an attorney. I'd say as an adjuster, you're probably closer to being an attorney than you would be as a paralegal, just because you're actually making decisions and, about the fact you're taking in evidence, making decisions, applying the law, and that's how it really works. Hopefully you're doing it, talking to your attorney on a pretty regular basis too, because you want to basically make sure you're staying in line with what the law really says. So from a comp perspective, in Texas is one of those states where we actually have two simultaneous systems working at the same time. And what happens is we have subscriber when an employer is a subscriber to workers' compensation, and we have non-subscriber. So in other words, in Texas, the Texas legislature allows certain large employers who can afford it to opt out and kind of maybe take the hit on the side on their own, completely apart from the protections of the comp system. Now, so this is going to be all about being a subscriber to the workers' compensation system. That means that all of the provisions that we're going to talk about today, all of the workers' comp cases we're going to talk about today, are governed by the Texas Department of Insurance Division of Workers' Comp. Now, they govern every aspect of this process. So what happened is back in 1992, really in 89, but it kind of became effective in 92. The Texas legislature took all of Texas workers' compensation and put it into a state agency. And the reason they did that is because before 1992, the court systems were like completely bogged down with workers' comp cases. There were more workers' comp cases in court in front of juries than any other type of case. We're talking like all the divorces, all the wills, all the probates, people dying, people getting married. There were more comp cases than that, and it was killing the system. So they actually took it out of the court system and put it into an state agency. And that's kind of what we're looking at today. That's what we mean by subscriber through the Division of Workers' Comp. Generally, there are going to be 5 steps to the courthouse. Okay, so these are each of the levels. Let me start before I even talk about these steps here for a second. Let's talk about more simply what we're really looking at with a comp case. I mean, in essence, you have an employer who has a workers' comp policy through an insurance carrier. Usually that policy and the adjusters are going to be hired either directly through the carrier or they're going to be hired by a third-party administrator, right? Who's going to be adjusting the claims. Now, in this scenario, you're going to have an injured worker. The injured worker is going to come forward and they're going to say, oh yeah, hey, I've been injured on the job. Something's happened on the job. They're going to report it to their employer, and their employer traditionally is going to turn around and report it to their carrier. Sometimes that process can get a little wonky because sometimes the claimant will go straight to the carrier. So and forgive me, when I say claimant, I'm talking about the injured employee or the employee who's claiming injury, one or the other. In Texas, all of our forms we're very form driven. So you'll see there's a lot of workers' comp forms, and the division who runs the system calls the injured employees claimants. So it's claimant versus carrier, right? So you'll hear me say claimant all the time. It's not I've heard in other states it might be derogatory or something. It's not in Texas. That is what the name of the party is, just like plaintiff in a lawsuit, right? So anyway, injured employee goes in, tells their boss, hey, boss, I've been injured on the job. Boss turns around, oh yeah, there you go. I like that. I have mood lighting here in the night here. So yeah, it seemed like by the way, that seemed like a great cost saving deal at the time. It wasn't. So I've never gotten it fixed. Anyway, so anyway, you get an injured employee, they go to their employer, they say, hey, boss, I've been injured on the job. The employer reports it to the carrier investigates the claim, decides if they're going to take a compensable injury or not, or if they're going to deny something, are they going to deny the whole thing, the denial of compensability, or are they going to deny some aspect of it, or are they just going to not deny anything and just pay and get, right? So ultimately, you have a case, it's chugging along, it's doing whatever, and somebody gets upset with the process. Either the carrier denies something or a medical report comes in that upsets somebody, and the aggrieved party, generally the claimant, will request a hearing. Now, in Texas, we love forms. That form is called a DWC 45. It's simply a request for a hearing. It's just a form that says request a hearing. So you file, and again, you'll hear me use acronyms. If you need me to stop and explain an acronym, stop me right there. I'll try and describe them as I go along, but this is the perfect example. So you got the claimant who usually files the DWC 45 request for a hearing. And that results in the setting of a benefit review conference. See that right there on number 1? Now, that benefit review conference is it's a 45-minute hearing It generally consists of kind of like it's almost like a pretrial conference. Are we going to can we resolve our differences? Kind of like a mediation. If we can resolve it, great. If we can't resolve it, what are the positions of the parties? A lot of times if I'm not going to resolve it, I'll use it as a CARES attorney. I'm a CARE attorney, of course. I'll use it kind of like to depose the claimant a little bit. I'll kind of get as much information as I can, and then we basically set it for trial. They can have 2 of these hearings, and then it must be set for trial on the issues. And keep in mind, everything in Texas is based on the issues. It's issue driven. Now, at that point, the parties will set. And by the way, the person who runs this benefit review conference, we lovingly call that the BRC, Benefit Review Conference, BRC. And the person who runs that is a benefit review officer, so they're called bros. So the bro runs the BRC. Now, the second round, see that arbitration? That's a unicorn. It doesn't exist. Nobody does arbitration. I think they did like one of it like back in the early 90s. It sucked, and so they never did it again, right? So, so you never see arbitration, but it's still technically on the books if you look for it. What they really do is they set from the benefit review conference, they set it straight to a contested case hearing. That's the agency trial. It's a bench trial. Okay, and the judge does only workers' comp, so they know comp very well. Usually that we go back and forth. In fact, the guy that sits right behind that painting on my wall there in the next office, he's the former head judge for Dallas. I hired him. So, so ultimately, what we do is the contested case hearing it's going to be just like you see in like court systems. So there'll be a counsel table. You'll have the plaintiffs or the claimant and the defendant, and we both do an opening argument. We do we cross-examination, all of that good stuff, and we okay. Oh, either way, I don't know if that was me or you. It works. So the person who runs that for years, the judge was called a hearing officer. So they were a hoe. So the comp system was run by bros and hoes. And the person, their docket clerk is called a proceeding resolutions officer, the one that actually runs the stuff behind the scenes for the judge. So they're called a pro. So it's bros, hoes, and pros. Now, recently the judges wanted a pay raise, so they changed their dang name to administrative law judge. So now they're ALJs. But you'll still hear like old school practitioners like me still periodically talk to one of the older judges and say, hey, what's going on with all the hoes? And we still say that back and forth. So it's real common to talk about it that way. But now they're technically called administrative law judges, ALJs. And then after whoever's upset with the decision from the court, from the trial, the contested case hearing, it's a write-in appeal to the appeals panel. And it takes about 45 days. You get 45 days they make 45 days to make a decision. There is no hearing at that level. It is like just straight up and write in and get a response. Okay. Whoever's upset with that, that is the final, that appeals to the appeals panel. The appeals panel decision is the final step in the divisions process in the agency. At that point, whoever's upset can file suit in district court, and you're off like on a regular district court case in court, but it's a modified de novo case trial. That means that whoever lost at the agency level has the burden of proof. Okay, so if the carrier loses, we have the burden of proof. So think about that, having to prove the absence of an injury. That's kind of tough. But I mean, it happens. You usually don't see judicial review very often in Texas, maybe only like 1 out of 100 cases. And the reason why is because it's really gonna have to be worth a lot of money to go into district court. Now, so let me see if I can. Oh, there we go. Oh, I got it. Okay. So let's talk a little bit about more of the process. And by the way, you guys can interrupt me if you want to at all. But okay, we start off, and you have the injured employee, and they're going to go and they're going to get injured on the job or claim an injury on the job, one or the other. And they're going to go and they're going to report it to their employer, right? Okay. So now, as far as the law goes in Texas, see where it says Texas Labor Code, right? That's the Texas Labor Code. That's actually the law put out by the Texas legislators. That actually is the law that governs this area of law. So that's actually the statute. What will happen is, remember, they also created a state agency, the Division of Workers' Comp, DWC, we call it the DWIC, or the division. They also put out rules. So you have Texas Labor Code, and you also have division rules. So you'll alternately see both of those are law, both of those are binding. And then you also have appeals panel decisions. Remember, you saw where we go to the appeals panel? The appeals panel, if they reverse anything, put rights of decision as well. And those are also binding authority. So, and if it goes to district court, any district court, once you get to the appellate level of the court system, that can also be binding authority. So you'll see me make references to court cases, appeals panel decisions, the Texas Labor Code, like you're seeing here, and the DWC or the DWC rules, sometimes it's called rule number, whatever. That's the DWC rule. Now, the Texas Labor Code here is basically a claimant comes to an employer, and the employer is required to report the claim to their employer or to their carrier within 5 days after a date of injury, if and only if the claimant loses more than 1 day of lost time, or the claimant's alleging an occupational disease. Now, what that means is this: think about this. Right now, I'm looking at my hands right now. I probably have 3 paper cuts on my hand right now. It's the great bane, the great injury of the attorney is the paper cut, right? But I didn't miss a single day of work. I didn't seek medical attention. So my employer, technically one of my, I guess my partners or something. The thing is, we don't have to report it to our comp carrier because I'm not expecting anybody to pay for medical, and I'm not losing time from work. So there's nothing for the employer to report. It's only if you're going to lose a day of work or they're claiming an occupational disease. So what is an occupational disease? An occupational disease is where a claimant alleges they were exposed to some stimulus in the workplace, like asbestos, and now they have mesothelioma, something like that. Or they're claiming, a lot of times we hear like we smelled something funny, and now I think I have a lung disease of some sort. So it's going to be like a transmission type claim. They're really only, if you think about it, there's only 3 types of claims. There's only 3 types of injuries in the whole world, right? Number 1, you've got your specific event injury. You know, the guy, you trip and fall, you break your knee, bam. Specific event, you know the date of injury, you know when it happened, you know where it is. Okay. What about the second one is like repetitive trauma? You know, the typist, don't tell her, but my secretary might have a claim for carpal tunnel. She types all day long. That's all she does. And if she ultimately developed carpal tunnel, she might have a claim for that, theoretically. Okay. So repetitive activity over time. And the third one is this occupational disease we're talking about. I smelled something funny and now I have scarring on the lungs or something. Now, if an employer does not report, if one of these things happen and the employer does not report it, the Division of Workers' Compensation actually polices the participants in the system. So that means somebody can refer the employer to a branch of the division called monitoring oversight, and that branch of the system could basically turn around and fine the employer for not timely or properly reporting an injury. So in other words, in Texas, like you probably see in other states, there's like bad faith claims, insurance bad faith claims. Bad faith claims in Texas workers' comp are essentially dead. There was a case a few years ago called Rudiger in district court. The court actually went all the way to the Texas Supreme Court. It killed bad faith in Texas in workers' comp. So the way that carriers are policed in Texas is through the monitoring and oversight department of the division. It's inside the division itself. So everything in comp is kind of subsumed within the division. Now, so in other words, those are the fines an employer can get. Now, once an employer reports a claim to the carrier, or the carrier gets written notice of a claim from some other source, once they get notice of this claim, they have 15 days to pay or dispute. So now this is where the adjuster comes into it, right? What is the adjuster's obligation when they've just been noticed of a claim? So they have receipt of a claim, they have received a written notice of a claim, and they then have 15 days to do generally a 3-point contact. They're going to call the claimant, the injured employee. They're going to call the employer to figure out what happened, and they're probably going to try and get the claimant's medical records to see what's happened. Lied again. So anyway, they're going to basically do this 3-point contact to see what's happening and if they have a basis for denial or not, whether they're going to pay or dispute. They have 15 days. If they do not pay, or excuse me, if they do not dispute by day 15 after the date the carrier received written notice of the claim, then they owe all disability benefits and medical benefits up until the date they do dispute. So in other words, because they don't want an employee to be without income, right? Because I mean, part of the system is to take care of the employees. Now, what did you say? Let me see here. Oh, there we go. Okay, so ultimately, the carrier has 60 days to file a denial of compensability in its entirety. In other words, the whole enchilada. That when we deny compensability, that's saying there is no compensable injury in the course of the scope of employment. That could mean a couple of different things. That could mean, number 1, this is not an injury. It could mean, number 2, we know you did it outside of the workplace. It's not work related. It could mean there's some sort of other defense that prevents us from paying. For example, like you were intoxicated at the time, you were on drugs at the time, or something like that, right? And I'll get into some of those defenses here in a second. But the carrier has, if the carrier does not dispute compensability by day 60, after the notice of the claim, receipt of the notice of the claim, then that means that the carrier is going to take that compensable injury from that point forward, and there will be a compensable injury. Now, the carrier might go on at some point further down the road and dispute some aspect of the claim, like they might dispute the extent of injury. For example, okay, the person fell, they struck their knee. We're going to take a knee contusion, but we're going to deny the, I don't know, disc herniation in the back at L4-5. Okay, based on the medical evidence. So the carrier can dispute extent of injury at any time, but they're bound by compensability if they don't dispute it by day 60. Now, notice that both these are the two waiver provisions of comp: the 15-day rule and the 60-day rule. Right? Pay or dispute by day 15, and if you don't dispute by day 60, if there is a compensable injury period, essentially the carrier would have waived an injury into existence. So, please note, we say with 15 days and 60 days, 15 and 60 days from what? From the date of injury? No. What about from the date the employer knew about it? No. It's those deadlines run from the date the carrier received notice of the claim. Okay. So that's the key. So a lot of times when I'm talking to an adjuster, they're calling me up and saying, and they call me, adjusters will call me every day and say, hey, Jeremy, I got a claim. I'm not sure what to do with it. Walk me through it. And I'll start asking questions. One of the first things they'll ask is, well, I'll say, well, tell me, what's the claimant alleging? How are they claiming they got injured? Right. And then the second thing I ask is when the carrier received notice. I'm trying to figure out, did we waive anything here? Especially if they're saying like the date of injury is like in July. I'll be like, okay, date of injury is in July. When the carrier received notice, so we don't have waiver here. That's what I'm looking for. Okay. So the question is what is notice of injury? That means notice of injury to the carrier. That is, there's the DWC rule 124.1. It defines a notice of injury as written when the carrier gets the employer's first notice of injury. We lovingly call that the DWC one. That's form number 1, the first report of injury. It's the employer's report of injury. So the DWIC 1. Or sometimes the division, like the claimant won't report to his employer, he'll go straight to the division. And then the division sends a notice to the carrier and said, hey, we've got a claimant here with this employer, and they say they got injured on the job. What do you guys know about it? And at that point, it starts a kind of big flurry of activity with the carrier trying to figure out what's going on. Suddenly there's all these anxious phone calls with the employer, trying to figure out what happened. Please note number 3 is, or any other written document, regardless of the source, that contains enough information to put the carrier on notice of the claim. That means the name of the injured employee, the identity of the employer, and the approximate date of injury, and maybe some basic assertion that there's a compensable injury, or somebody's alleging it's a compensable injury. It doesn't matter how ridiculous the assertion is, as long as it's on there. So remember, think about what that could be. Like, what if the carrier gets like a chiropractor's bill? Well, chiropractor's bill has the name of the claimant on it. Generally has the name of the employer on it. They're sending it to the carrier, so they're saying it's work related, right? And there's an approximate date of injury on there. Bam, the carrier just has written notice of the claim. That starts at those deadlines. Okay. Now, just to make it even more exciting, remember it says any other written document. So, what is a written document? I know you're gonna say, no, wait a second here. I know what a written document is, right? Do you? Because here's where I'm going with this. The employee's first note report of injury, so the employer can put in a report of injury. We call that the DWIC 1. That's the form. The employee can also put in a report of injury. That's the DWIC 41. Don't worry about the numbers. You learn them in practice when you start doing it, right? But what about this one? What about an oral report from the employer? That's been held to be a written document. What? An oral report is a written document? Now, hold on. So that means, think about this for a second. You're an adjuster. You get a call from your employer. So now you know who the employer is, right? You know who the person is, your contact is. So you know which employer you're talking about. And they say, hey, I got this employee, Johnny Claimant. He says that he got injured when he says he fell, but I don't know anything about it. We didn't even know anything about a fall. Do I have to report this claim? You just did, sir. You just reported it. You just told your carrier the name, the approximate date of accident. There was an allegation of work relatedness, and they know who you are, so they know who the employer is. So the thing is, that counts as a call. So sometimes what will happen is employers, savvy employers will call and say, hey, I've got an employee who says they did this. What do I need to do? Please note, they don't give the name of the employee. That's so they avoided a written report of an employer. So they can still get legal advice from their adjuster, basically, right, about what they need to do. A letter from the claimant, a call from the division, a telephone call from a medical care provider. So even a call from a chiropractic clinic going, hey, we understand that you're the carrier for this claimant. That counts as written notice of injury. Okay, so keep that in mind. That's always why I was asked, when did the carrier receive notice of the claim? And carriers are very, very diligent about documenting when we got the notice of the claim and how we got that notice. So they know the day. Their system requires them to put it in because that's why, because of waiver issues. Okay, now, so let's talk a little bit. Does anybody have any questions so far? Like I said, just throw them out there if you want to. So let's talk about, as says, bases for controversions. I like using the term controversion because it sounds fancy, but that's a denial, right? That's a carrier denial. So what are the reasons for denying claims in Texas? What are the things that we might deny a claim for in Texas? What are the things that should make you as an adjuster, when you see it, go, okay, well, what about coverage? Now, you're going to think, wait a second, coverage. Remember, workers' comp is a policy-driven system. An employer gets a workers' comp policy through a given carrier for a set period of time. So you should know what your policy periods are. So if you get a claim for a date of injury that's outside of the policy period, they have a coverage problem. Now you're going to say, wait a second, hold on. Like these policies, you'll have an employer, they'll have the same policy for years. Years they have the same policy. I mean, decades sometimes. Why would that be an issue? Here's why. Remember we talked about the 3 types of injuries in the world? Okay. Specific injury. You fall, you break your knee, bang, you know the date of injury, you know it's a specific event, it's a hard date of injury. It's a tack in the page, it's a tack in the timeline. You know when the injury is. It's when they broke their knee, when they fell and broke their knee. But what about the other 2 types of injuries? What about repetitive trauma? What about repetitive trauma? Right? Repetitive trauma could be like, well, a lot of times when you're investigating the claim as an adjuster, you're going to be talking to the claimant, you'll be taking a recorded statement. And what if in the recorded statement the claimant says something to this effect? Yeah, I've been having this elbow pain, and I think it's from repetitively lifting boxes over time, and I use a hammer too, right? So I think that the elbow injury is from repetitive use of the hammer, and maybe a repetitive lifting too. All right. So ultimately, what you do is you say, okay, well, how long have you been having the problem? Oh, I've been having this problem since the first week I started this job. Well, sir, I see down here that your date of hire is like January 1st of 1995. Have you been having this problem since 1995? Well, yeah. Okay, then your next, by the way, is an adjuster in your reported statement. The next question should be something to this effect. The next question should be, well, hold on now. It says here that you just reported this claim for the first time to your supervisor, Mr. Smith, like 2 days ago, like on, what is it, November 12th, 2021. Is that right? Oh, yeah, that's right. Well, you've just created a bunch of defenses, right? One is, well, they haven't reported the claim within 1 year. That's a big one. They haven't reported the claim to the employer within 30 days. That's another big defense. You'll see that's timely reporting down there coming up. And you might have a moving date of injury that moved it back to January 1st of 1995 or January 7th of 1995. And you may have a coverage problem because this employer may not have had coverage with this carrier, Zurich American or Hartford or whoever you're using back in 1995. You may now have a coverage problem because the date of injury is the date the employee knew or should have known that it was work related. Well, if they said, yeah, I knew about it and it was work related, doggone it, and it was work-related from January 7th, 1995, your date of injury is January 7th of 1995. And that's what we use a recorded statement, by the way.
But are employers required to have it though?
Are required to have workers' comp coverage?
Yes.
Yeah, they are required to have coverage of, they are not required in Texas to have workers' compensation coverage. If they have workers' compensation coverage, they are a subscriber to workers' compensation. If they do not have coverage, they usually have some other plan in place, which is usually like an ERISA plan or something. And those are called non-subscribers. Non-subscribing employers, they're not subscribers to the system. They're not part of the workers' compensation system through the division that we're talking about here. But so they can be non-subscriber, but that means they're essentially running, they could be out there with an ERISA plan that protects them, like a lot of big employers. Walmart does that, for example, right, in Texas. But that means come and sue me. If you think you can get it, come and sue me. That means they're going to get sued every time, or sued. Their ERISA policy will take care of it, and then when something goes wrong, they might get sued for something outside of the ERISA policy. They're going to go straight into district court, which will then move into probably an arbitration system. That's a different seminar for a different day. I'm not talking about, if I talk about subscriber and non-subscriber at the same time, it'll just get things really wonky. But yes, there are two simultaneous systems in Texas.
Yeah. Actually, I got that in my notes in my bag.
Right, so we're talking about just subscribers within the system who have a workers' compensation policy through an insurance carrier in workers' compensation that goes through the division. That's kind of the standard in Texas. Now, so what about employer-employee? Now you're thinking, okay, wait a second. My employer is going to know if they're their employee or not. And I'll tell you, having done this a time or two over the last 20 years, that's not always true. Here's the kicker. Okay, so there's a couple of ways to show employment status in Texas. Number one is the way that you would normally think. You have an employer, the clinic comes in, they have an application, they pay employment taxes, they pay their paycheck, they do all these other things, right? Great. That's probably going to establish they're an employer. Unless they have paperwork that says they're an independent contractor. Uh-oh, wait, what? Now, what if there's even contract information saying that they're an independent contractor and they need to carry their own comp because this is not an employer for purposes of comp? Ooh, that might be a problem. What about temporary workers? I represent a lot of temp companies. And in the temp companies, think about this. You go out and you hire a temp company, a Randstad or a Manpower, something like that. All right. The thing is, you hire the employee, you bring them into your warehouse. They're working in your warehouse. You're telling them what to do, but technically, you have a contract with the temp service saying that the temp service is the one that covers the policy, has the policy to cover them for workers' comp. They're the responsible employer for workers' comp. Okay. So maybe they're not the employee of the client company. Hold on to that thought for just 1 second. Let me say one more thing. There's another way to become an employer-employee in Texas. That is called the right of control test. Right? So let's say this. Let's say I'm doing this seminar, and let's say we were live, and I turn to Tamar and I say, hey Tamar, listen, I've been drinking coffee all day. Actually, I've switched to tea, but I'm drinking coffee and I got some bad breath here, and I'm not sure. I need some of that cinnamon gum. You know what I mean? So would you mind here? Take my car and run down to the store and here's $20 and grab me a stick of gum and keep the change for your troubles. Have I just hired Miss Bibbs? Maybe, because start adding more control to it. What if I said, well, you can only go to that 7-Eleven, and yeah, use my car, and you can't pay more than $1 and $1.07 for that gum, and I start putting more and more control over it. I may have actually hired her. And when she gets in a car accident on this mission that I've sent her on to go get some gum, do I need to have comp? Maybe. So go back to that dual employment thing, right? That you have a temp service. And in the temp service, you've got an employer who hires them and pays their paychecks and sends them out to a client location, like a warehouse or something. Who is the employer for purposes of comp? Is it the temp service, or is it the owner of the warehouse who's really making them use all the equipment and telling them what to do on a daily basis and controlling all of their activity over time? Who's the employer?
The warehouse, right?
So
my
would it
guess.
be the temp service? Because they were the initial people who hired them
Yeah.
for the warehouse.
And they have
right?
the contracts and everything, right? But
Correct.
what about the right of control test? I mean, the
Right.
temp service isn't telling them what to do on a daily basis. You see the dilemma, right? Because the warehouse is the one that's actually telling them, go pick up that barrel and move it over there, right? You know, and use our forklift, right? The answer is dig this. They're both the employer. Dual employment in Texas. But what's going to happen is the owner of the warehouse is going to say, but I have a contract with the temp service to be the responsible one. But there is dual employment. We're both employers. But the temp service is the one that is the responsible employer for purposes of comp. Why do they want to be dual employers in Texas? Yeah. The reason they want to have dual employment in Texas is because the reason you get comp in Texas and don't go non-stop is because you don't want to get sued in district court for negligence. So you want the exclusive protections of the Texas Labor Code, which says the exclusive remedy for worker injuries on the job with a covered employer is through workers' comp. And there are limitations, and there's defenses, and there's all these wonderful things you want to block you, limited caps on numbers and stuff, you know, caps on the high amount of numbers, caps on the duration of numbers of payments, all these protections you want in comp. You want your case to be a compensable. If it's going to be compensable, you want to be covered under the comp policy. And you want to be a covered employer and say, hey, you can't sue me. I'm an employer who's provided comp through the system. Thank you very much. Now, okay, what about another defense here? What about timely reporting? This is what we lovingly call the 30-day defense. An employee in Texas has 30 days to report an injury to his or her employer. Right? And that means they have to go and they have to explain to the employer how they got injured and what happened. At least say they got injured on the job site. Right? They got to give notice to the employer. So the question then becomes is, wait a second, what's notice to the employer? Well, we've seen briefly before where they'll admit and say, yeah, I've been having this problem for some time, and they throw the date of injury back in time, but they admit they only just reported last week and a recorded statement. That's a pretty clear. That'd be the best piece of evidence for the timely reporting defense. They didn't report it to their employer within 30 days. It's no longer a compensable injury. But what about scenarios where I'm working at the work, I'm an employee of the company, right? And Cecil's my boss. And I go to Cecil and I say, hey, Cecil, you know, yeah, my back's pretty sore. She says, oh yeah, what's going on? Well, I went water skiing this weekend. Did I just report an on-the-job injury to Cecil, my employer?
Nope.
Yeah, why? Because I didn't create that nexus, that connection between work, right?
Mm.
Okay. Now dig this. What if I go out and I treat with my own group health practitioner and I find out, holy gosh, I've really screwed my back up. And now I need to have a surgery and I'm going to be off work. And I can't afford to be off work. And I can't afford that deductible under the insurance policy, under my group health insurance, right? So I come back in and I say, man, you know what? I think I hurt my back from lifting all these barrels of liquid. And Cecil, by the way, remember when I talked to you 3 months ago at a water cooler and I told you my back was bothering me? Remember that?
Mm.
And you're gonna say, yeah, I remember. And the employer should be savvy enough to say, yeah, I remember you telling me your back was hurting. You didn't say anything about being work related, right? And here's the deal. What's going to happen is the employers, because the employee is now alleging it's work related, the employer's going to have to complete that first report of injury, and because now the employee's injured and they're going to go off work, right? So now they say, now the employer's going to have to complete that first report of injury, and on the first report of injury, there is a little box down there that says date reported. And what if the manager, Cecil in this case, what if I say, well, my date of injury is July 1st, 2021. And I said, remember I reported it to you. We talked about it on the water cooler like on July 2nd, 2021. What if Cecil puts in that box, date reported July 2nd, 2021? That may cause a problem because now, remember the first report of injury, that is the employer's report of injury. That's the employer's version of events. So now the employer, in that case, Cecil, put down the date of reported is July 2nd, when in reality, he clearly didn't connect an injury to the workplace back on July 2nd. He didn't say anything about it until what? November 14th. See, more than 30 days later. But Cecil put down when he did the first report of injury, the manager, not thinking about it, not realizing it, put down the date reported as July 2nd. You see, they filled out the form wrong. You see? And that happens, by the way, all the time. And what I have to do is I then have to go to that manager and say, here's what we're going to have to do. I'm going to have to get an affidavit from you that says you don't know how to fill out forms. You erroneously filled out the form, not thinking that you were supposed to write down what he was saying, not what you really knew to be true. And that's always a fun affidavit to make somebody sign.
That's a hairy situation. So my question would be, being that he claimed it was work related after the fact, and he's filling out the form, so he would say the date that he actually reported work related on that form.
Yeah.
But would it have been in the best interest of the employer at that time when he stated that he hurt himself unwork related to have noted that time?
Yeah. Are you saying let me make sure I understand the question. Are you saying that it's a better thing? Yeah, it's better for the employer to have written down the form. No, the date reported was the day I'm filling out this form, November 14th, 2021. That's why I'm filling out this form.
Right. Yeah. So,
yeah,
right.
that's what you want the employer to do. But employers don't do that. Because remember, half the time the employer, there's like another janitor or something, there's higher up in the ranks. You know what I'm saying?
Right.
So they don't know how to fill out the form. So we get forms filled out incorrectly all the time. But here's the trick. Your job as a comp adjuster goes like this. Your job as a comp adjuster goes like this. You come in and you say, wait a second, I'm getting this form on November 14th and it says date of injury July 1st, 2021. And first thing you do is you're going to call the employer and you're going to say to the employer, hey, wait a second, employer. Why am I getting this form so late? I mean, why didn't I get this form back in July? And that's when the supervisor says, well, because they didn't really tell us about it until November. You see? And that's when you got to go, well, let's fix the form then. Do an amended form and let's fix it. Right? So, okay. Does that answer your question? Oh, yeah.
It does. So my follow-up is, being that, so is it a situation where it's his word against the employer, being that the employer knows for a fact that when he initially did report it, it was not work related?
Yeah. It's gonna be a he said, she said. It's absolutely gonna be a fact issue for the judge to decide. Right. And I would say there are some other things we're going to look at in a case like that, right? What are the other things we would look at as an adjuster, as an attorney? What would we look at, right? We're going to look at, well, number one, where have you been lately? I mean, if your date of injury is July 1st, how come you didn't seek treatment until freaking November? Or how come you treated under your group health insurance and paid for all these medical visits all along until you found out you needed surgery? When did you find out you needed surgery and we're going to be off work? Oh, November 13th, and then you reported November 14th. Isn't that convenient? You kind of see how things kind of work in. The other thing is this, hopefully your adjuster, as an adjuster, you're going to be going out and taking a recorded statement. And in that recorded statement, you're going to ask the claimant. So when did this happen? Oh, I think it happened July 1st, 2021. Now I have down that this may have gotten reported November 14th. When did you report this claim? Was it November 14th? And if they say, yeah, well, their own recorded statement is going to sink them, right? You kind of see how we use different pieces of evidence to kind of prove things. Plus, they're going to take the stand, and I'm going to question the heck out of it, right?
So would this, I have a quick question, Jeremy. So would this come up in the benefit review conference, or like at what phase during the?
What would happen is employer employee goes to the employer, figures out whatever happened in that scenario, right? The employer files the first report of injury. You with me? The carrier gets the first report of injury, and you as a new comp adjuster, you as a comp adjuster for this policy holder, you're going to basically be investigating this claim. So you're going to get a new claim across your desk, and you're going to see, okay, it says November 14th is the day I got it, and it says date of injury July 1st. Wait, what? What's going on here? And the first call that you as an adjuster are going to make is you're going to call the employer and figure out what happened. Then you're going to turn around, and once you figure it all out and say, okay, it really was a date of injury of July. They really didn't report it till November, according to the employer, really, even despite the fact they screwed up the form. So you're going to deny the claim. You're going to file what's called a PLN, plain language notice. Those are fancy words. Those are the actual forms. When we talk about the DWC-1 for the notice, the first notice of claim, the denials are called PLN ones. Okay, so you're going to file a denial of the claim, and your denial would say something to the effect of, oh, carrier denies the claimant sustained a compensable injury in the course of scope of employment. Carrier denies disability. Carrier is relieved of liability due to the claimant's failure to timely report this claim to the employer. Bang. Denied. And then what's going to happen is the claimant's going to be all pissed off about it. And they're going to file a first forward, a DWC 45, that request for the hearing. And then you're going to get a BRC. And then I'm going to show up on the BRC and say, or your attorney's going to show up on the BRC and say, okay, tell me what's going on. And I'm going to gently prod them into a scenario. And and remember, when I'm at the benefit review conference, if I can run them off, I might. But most of the time, by the time they get to BRC, they're ready to go fight. And they're ready to fight if they're coming to a hearing, right? So I'm not necessarily going to show them my cards. A benefit review conference for an attorney is kind of like the first round in a hand of poker. You know what I'm saying? It's like, I want to know what he's got, but I don't want him to know what I got. Now, if I think I can get him gone, then I'll just lay it all on the table and say, come on. You know what I mean? But otherwise, if I can tell he's not going away, I'm trying to get as much information from him and not give him as much. Because I'm gonna basically ambush him in the trial, right? In the CCH, the next level, where it matters, where the judge makes a decision, right? So a lot of times with the benefit review conference, your attorney in the BRC is like, okay, so tell me what happened. Oh yeah, okay, cool. Yeah, and then what happened? Well, yeah, why'd you do that? Huh, cool. Yeah, okay. So who was your primary care physician anyway before this? You know, it's real gentle, easy, tell me a story type questions, right? And then in CCH, then it's another story. Then it's cross-examination, right? So you see how it works? Now, okay, what about course and scope of employment? The queen mama of all defenses there. That's the big one. Okay, so remember, workers' compensation coverage is for injuries that occur at work, in the workplace, while at work, right? All right. So what this means is it's not group health. Workers' comp is not group health. Keep that in mind. Okay. Group health, you pay for it, they cover everything wrong with you, whatever, right? There may be some exclusions in your group health policy, maybe for like, whatever, but certainly for workers' comp claims. So, but if it's comp, it's only going to cover what's work related. So how do you know something's work related? What's the standards? Let me give you two standards the divisions use. Number one, what at the time of the injury was the employee engaged in the furtherance of the business affairs of the employer? In other words, were they working while at work? Right? All right. Pretty basic. Now, you think it's basic. Hold on to that thought for a second about how basic it is, because it's not basic. Now, what about? And the second one is this injury, whatever this condition is it of the kind and nature inherent in the workplace, or is it rather pre-existing and degenerative in nature? For example, heart attacks, right? Heart attacks are almost never compensable, right? I mean, I guess if you're working for 7-Eleven and you're a clerk at 7-Eleven and some guy comes in and is pointing a gun in your face and you have a heart attack. Okay, mate, that might be a work-related heart injury. But if you're just sitting at your desk working, you have a heart attack and fall over dead at your desk, like I'm probably going to do, right? ultimately, it's probably cardiovascular disease and ordinary disease of life, and not the fact that I'm, giving a seminar about workers' comp that's causing me to have the heart attack, right? I mean, let's be frank, okay? Or, oh my gosh, I'm older and I have osteoarthritis in my shoulder. I got bone spurs in my shoulder. That could be from the fact that I don't know, lifted this cup of coffee or whatever, but it probably isn't, right? It's probably from the growth of bony growth of calcium over your bones over time. It's a degenerative process. Okay, so let's talk about working while at work. Okay, now obviously some things are you're pretty clear. You're working at work. You're picking up a file. You bend over to pick up a file off the ground, and your back pops. You're in a warehouse and you're loading something onto a forklift, and you strike your knee against the forklift. You know what I mean? I mean, pretty obvious things, right? They're going to be working while work. You're clearly furthering business affairs of the employer. Okay, but what about travel to and from work? Well, travel to and from work in Texas is generally not compensable. So if you get in a car accident as you're driving to your regular place of business, generally that is not compensable. Okay. There could be some exceptions to that. Let's say, but then you say, okay, well, hold on. If I get in my car at my house and I'm pulling out of my driveway at my house into the street of my house, and I'm go driving to work, and I get rear-ended, I get smashed like T-boned, probably not compensable. I'm driving to and from work, right? What about when I'm almost to work and I get T-boned as I'm turning to turn into the parking lot of my employer? Are you on a public street? Are you in the parking lot? Are you in the driveway of your employer? Are you in your employer's property? Generally, the property line has been held to kind of be the mark as to when you've arrived at work. But wait a second, you're not working while at work yet. You're just driving to work yet, right? Well, here's the kicker. Remember we talked about the appeals panel earlier? The appeals panel has actually, through a series of cases, has expanded the concept of working while at work. They say that there are some things that are so inherent in working while at work that they must be compensable. For example, you have to get into the workplace. So when you're walking across when you're in the employer's parking lot, walking across the employer's parking lot, not the parking lot across the street, the one you pay for, but in your employer's parking lot, you're walking in and you trip on the door sill as you walk in the front door. You haven't got to your desk yet, but you trip and fall and hurt yourself there. That will generally be found to be compensable when you're coming in at the beginning of the day, leaving at the end of the day, or going to and from lunch. Okay, those 4 little trips, they call that the access doctrine. You must have access to your workplace. Okay, in other words, the appeals panel has expanded the area of the workplace out to the curb of the employer, essentially. Okay. Now, the other thing is called the personal convenience doctrine. And the personal convenience doctrine, they expand the nature of the things you do in the workplace, because they say some things that we do in the workplace are so inherent in work that they should also be covered. For example, going to get a drink of water, going to the bathroom, going to get something out, like getting a cup of coffee or something out of the break room, right? Those things are, they say that those are part and parcel of working while at work. So if you get injured in the bathroom, or you're going to the bathroom, I actually had one case where a granite stall fell on a person, like just like collapsed and like fell on a person. I mean, like broke some bones and stuff. It was bad. And of course the adjuster calls and says, Jeremy, that's not compensable. They were in the restroom. I'm like, well, that's personal convenience doctrine. I mean, it was an employer's restroom, right? Yeah, we're covering it. But what if I have like one of those shy bladders, right? You know, and I don't like peeing in the workplace. So I like to go across the street to the Starbucks and use Starbucks' restroom. Well, now I've left the workplace. That's not the employer's premises. That's what we call a special mission. You're doing that for your own special reasons. I mean, that's called a personal deviation. You are now deviating from the workplace. And what if I get up at work and I trip over my own 2 feet and fall down and hit like a filing cabinet and slash my arm open? Yeah, that's compensable. But if I'm doing it while I'm in the middle of in a personal deviation, like I'm going to Starbucks to go to the restroom at Starbucks, or to go get that little frittata thing at Starbucks because I like those, right? I'm not going to the employer's break room. I'm going to Starbucks across the street. From the minute I get up and start walking towards the door, all of that is like you have left you have left the river of employment. You are now on your little personal stream of personal deviation, right? I had a case one time where a claimant, she said, and it was in the recorded statement and everything. She said, she goes, yeah, okay, here's the deal. I don't use my personal cell phone for work, but my daughter was pregnant and she was going to go into labor at any time. So I told my boss, I said, hey boss, I left my personal cell phone in the car. Do you mind if I run out to the car and get it? And he said, yeah, sure, go ahead. So then she went out the door, and as she did, she tripped and fell on the stairs, and she fell down and broke both ankles. Yeah. Real stories, right? And so the thing is, so was that compensable or not?
Well, be yes, because she was still on the premises. Huh?
Yeah,
No,
but she
no,
was on
no.
her personal mission.
That's right. Personal
like-
mission. It was personal deviation, right? It wasn't access at the beginning of the day or ending of the day. It wasn't at lunch. So it wasn't one of the 4 getting access to your workplace. You got to get to your workplace from getting there. But although it's on the employer's premises, she got up from her desk to walk out to get a personal cell phone, she had left the course of employment. She was now engaged in a personal deviation. Okay, see how it works?
Yeah.
Yeah, I know. Right.
How does that work for like gig workers? Like, are they on the clock when they accept like an Uber ride, or do they even have workers' comp for like gig workers?
Like what kind of workers?
gig or like Uber drivers.
Oh, Uber drivers? Well, yeah, I mean, they could be in the course of employment, absolutely, right? And so it's like, so if they're like in the middle of a run, right? You know, they've accepted a job and they're in the middle of a run. I mean, you can tell real quickly if they're in the course of scope or not, right? Because if they're just sitting around, you know, that's the whole point about being, you know, about Uber drivers. Everybody I've heard about Uber drivers is, yeah, I can work when I want to work and I don't want to work when I don't want to work, right? So
Right.
yeah, I guarantee you that Uber can track when they've taken a dang fare, right?
Mhm.
You see what I'm saying? So that's part of it. So yeah. Now, or if a passenger gets in and gets all crazy and punches him in the head or something like that, probably compensable, right? All right. So now let's talk about one last thing about travel. There's another type of travel called special mission, not personal deviation, special mission. You're on a special mission for the employer. Okay. That's generally what we generally tend to refer to as business travel. Okay. Now, for example, I oftentimes travel around the state of Texas. I live in Dallas. I may have to travel to San Antonio. For those of you who aren't familiar with Texas very much, Dallas and San Antonio are not close to each other. They're like 5 hours away from each other by driving. So I usually fly there. And so if I'm driving from my office to the airport, or even from my front door straight to the airport, all of that travel, if I'm not going to my office, so I'd be going straight from my house to the airport to jump a plane to go to San Antonio to do a hearing and come back again. All of that is covered as compensable because I'm engaged in a special mission. And that means that even when I am in San Antonio and I have a break while I'm waiting for my plane and I go to eat a meal and I choke on a chicken bone or something, right? I got to eat. That's part of the mission. I mean, it's reasonably foreseeable. So that is also compensable, interestingly enough. So all of the things that would not be compensable might be compensable in the course of a special mission. But what if while I'm in San Antonio, you know, so that means eating, getting a cup of coffee, driving around, all of that's compensable when you're in the course of a special mission, a business trip. But what if while I'm in San Antonio, I decide, man, you know what? I haven't seen the Alamo. I'd like to go see the Alamo just because. And I decide I'm going to take a little bit of a break and I'm going to drive over and see the Alamo because I want to. Not for my job, nothing like that. Now I have left the course of my special mission and I am now engaged in a personal deviation. Do you see how fine-tuned that is? It's back and forth. That's why these questions about what were they doing? You'll hear me start asking questions like, what were they doing? Where were they going? Why were they there? Where's their employer? Where's their employer's location? Where's their business location? Where's their residence? And I'm like map question. I'm like seeing where it is on the map question, see where the accident occurred. Did it really occur between the place of business of the employer or where or what? Right? What were they doing? Okay. So yes, it is that detailed as to what we're doing when we go down and do this investigation. Travel deviation. Okay, cool. Yeah, we've talked about that. The last one there, we've already talked about ordinary diseases of life, things that generally would not be compensable, generally or not. So things like your traditional things like arthritis, which by the way, if you don't know your anatomy, arthritis goes like this. In the neck, it's called cervical, they call it intervertebral disc disease or degenerative disc disease. In the knee, it's oftentimes called chondromalacia. In the shoulder, they call it impingement syndrome. These are words that are like, these are the other words that mean osteoarthritis. Okay. So so if you don't know what that is, you know, any liver disease, you know, because, you know, I had too much wine last night and I ended up with liver disease or something. I don't know. Right. You know, the thing is, these are things that are probably never going to be compensable or that they're going to have a hard time proving they're compensable. Okay. Skip down to NICC, notice of injury and claim for compensation. That is the one, what we lovingly call the 1 year defense. Okay, an employee has 1 year from the date of accident, date of injury, to report a claim to the employer. Okay. To file a claim. That's sorry. To file a claim with the Division of Workers' Compensation. Sorry about that. I misspoke. So remember, they have 30 days to report to the employer, but they also have only 1 year to file a claim for compensation with the division. So what happens is, this means that if they report a claim and the carrier denies it, a lot of times I get questions about, well, what do we do now? We've denied the claim. What do we do? You sit and wait. Or you can just close your file if they're not doing anything, right? You know what I mean? In Texas, we don't settle cases in Texas. There's no such thing as settlements in Texas, like in some of your other states, or like in liability cases. So there's no settlement. So we are on the hook for all future medical that is medically reasonable, necessary, and related. That's why a lot of times we'll deny the extent of injury and say, oh, fine, it's only a lumbar sprain strain or whatever. The treatment for a lumbar sprain strain probably lasts, 3 months, we're basically done. We start challenging treatment after that. But in this case, if they don't report it, if they don't go to the division, if the claim is denied and they don't go to the division within 1 year and file a claim for compensation, then that claim is barred for forever. It's like a statute of limitations almost, kinda, right? What about if they throw the date of injury back? Remember, like remember early on we talked about I've been having this problem since 1995, and they threw it all the way back. This is a second offense. Not only did they not report it within 30 days, they also didn't report it within 1 year to the division. You just kind of see how these are like the waiver provisions for the claimant. Remember at the beginning we talked about the 15-day rule and the 60-day rule for the carrier, the waiver provisions for the carrier. The 30-day defense and the 1 year defense are the waiver provisions for the claimant. That's how claimant waives the carrier's liability for the claim.
Gotcha.
Yeah, let me see here. Let me see if I can use. Okay, what you found there. Okay. Affirmative defenses. Okay, let's talk about some of these here. These defenses, these are situations where you have a claim that would be compensable. It's in the course and scope of employment. They were injured, on the job, but for some other reason, the carrier is not going to be liable for it. In other words, it's still going to get a denial of compensability. And these are defenses that have been laid out by statute in the Texas Labor Code. Okay, so in other words, they would be compensable injuries, but for some other reason they're not. Right? In other words, these are the 5 or 7 affirmative defenses here. Intoxication, for example, in Texas is draconian, very hardcore on intoxication compared to any other state. I've never seen a state that's tougher on intoxication than Texas is. Okay, so intoxication can be proved a couple of different ways. Number one, obviously you take a blood alcohol test, urine test, breathalyzer test, and you blow 0.08, right, for alcohol, and you haven't had a chance to drink beer or alcohol between the time of the injury and the time of the test, that's about the closest thing in Texas we have to a slam dunk if they blow 0.08 or higher. It's the same thing as like you blow when you're driving on the road, right? And the cops bust you. All right. So what about drugs? Okay. When dealing with intoxication due to illegal drugs, basically the carrier has the burden of proof in these affirmative defenses. The claimant has burden of proof on all the other stuff, but in these affirmative defenses, the carrier has the burden of proof. So what do we do about drugs? Well, here's the deal. Texas says that upon the presentation of a positive drug test, there is a legal presumption that the claimant was intoxicated at the time of the accident, and that they did not have the normal use of their mental and physical faculties. In other words, there's a presumption that it is not a compensable injury if they have a positive drug test. So the question now becomes, now you're going to open up the door to a million questions about when was the test taken? What kind of test was it? What kind of drug was it? What if it is Junior taking mama's Valium and he doesn't have a prescription for it? Oh, still an illegal drug, right? What we do is the employers will get a urine test or a drug test or a blood test, right? And then if it comes back positive, the employer and the drug testing facility needs to run a second confirmatory test based on the same sample. They don't go out and get another sample. Okay, they use the same sample and test the second time and tell you how much of the intoxicant metabolite is present in the sample, right? So for example, and that's important because we want to know, because we can then go to a toxicologist and have a toxicologist issue a report that says, the test came back, it showed so many nanograms, it showed 400 nanograms per milliliter of THC, but carboxy-13, which is marijuana, right? And based on that number, the claimant would have been intoxicated at the time of the accident. And so what you're doing is you're looking and saying, well, you want to get that drug test as close to the time of the accident as possible, right? Because you don't want the claimant to be able to get out of it as a carrier. You want, if you're going to assert intoxication, you want that drug test to be right there on top of the date of injury. Because otherwise they could say, oh yeah, yeah, I didn't take the test for 3 days, but I went home and I was in such great pain, and I know I shouldn't have, but my brother-in-law, he had a joint, and I smoked the joint because I was in such great pain from the injury. And yeah, that's why I tested positive on the drug test the next day. You see, so you don't want to lose what we call control. You want to lose physical control of the claimant in the meantime. But that does happen all the time. Things like this is also when it's really a good thing for recorded statements in this case, for adjusters to take recorded statements too, because one of the questions you ask just among your laundry list of questions is, have you ever done any illegal drugs? And if they say, yeah, you say, how long ago was it? And they, oh, back in high school. Okay, more than 10 years ago? Cool, yeah, okay. So you haven't done illegal drugs in 10 years? Perfect, move on. Next question. What's your, who's your name, your PCP or whatever, right? Your primary care physician. But you get it all the time where claimants say, no, I've never done drugs. I've never done drugs. And they come back with a positive test for cocaine or something. And it's pretty clear they've done drugs. They're lying to you. So now they then try and tell the judge later on, okay, yeah, I did the cocaine, but I did it on such and such date. It was a different day, da 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 da. I said, and that's when the recorded statement really comes in useful, because then you turn in cross-examination and say, now hold on just a second. You gave a sworn statement under oath saying you've never done any illegal drugs. So were you lying then or are you lying now? Which one is it, sir? Right? And it's a tough thing. So anyway, that intoxication is definitely, if you ever get one of those, definitely make sure you get the confirmatory test, and you'll probably get a toxicologist to weigh in on it too through your attorney. The willful attempt to injure oneself or another. These are the suicides. Suicide is not compensable. The attempt to injure oneself or another. That's also the guy who's throwing the first punch in the fight, right? The puncher, the guy throwing the punch, right? The guy, you throw the first punch, and you throw the first punch in Texas, then you get your butt kicked. It's not compensable. You threw the first punch. Well, even if they were saying really bad things to me. Yeah, but you threw the first punch, man. It's not compensable, right? You're the puncher, willful attempt to injure oneself or another. Okay, that's the defense. So your denial would look something like: carrier denies the claimant sustained a compensable injury in the course and scope of employment. Carrier denies disability. Carrier is relieved of liability under the affirmative defense of a willful attempt to injure oneself or another. That's really how it sounds. It sounds like it's totally crappy English, but that's what it really sounds like. That's really how it reads. But that's, you're raising that defense. What about the intentional act of a third person? That's the dude who gets punched. That's the punchee, the guy that gets the guy hit. Okay, and what happens is the question then becomes is that might be compensable, because if they got punched over something to do with the workplace, over something to do with the work, it's compensable. But if they got in a fight because of last night's Cowboy game, right? Because they were saying that Atlanta should have won or something, and our guy said, no, what are you talking about? We're from Dallas. You should be supporting the Dallas Cowboys, and he gets punched for it. Well, the thing is, that fight had nothing to do with the workplace. In that case, that intentional act of a third person is a defense to the carrier's liability, and it is not a compensable injury. So in other words, whenever you see a mutual combat case, you always want to say, what were they fighting about? And the employer goes, I don't know. You're like, well, let me talk to them. That's what are they fighting about? You want to know what they're fighting about, because they're fighting about the fact that one guy's sleeping with the other guy's girlfriend. Not compensable, right? That has nothing to do with the workplace, right? So anyway, that's the one. Keep in mind, on the other hand, if they're getting injured or they're getting attacked because of being in the workplace, because they were in the workplace at the wrong time, place at the wrong time, that is compensable. So, for example, we had a case a few years ago in Dallas Love Field, the airport, and some guy walked in, and he walked up to the Hertz counter, and the Hertz rental car counter, and he shot the guy behind the Hertz counter with a gun, obviously, and he shot the guy behind the counter because the guy was sleeping with his wife. And then he turned around and he shot the lady standing next to him just because she was there. Now, obviously, the first guy is not compensable because he got shot or attacked for non-work related reasons. But this lady, the second one, she was compensable because she got attacked because she was just working at work, right? There was no reason for her to be attacked otherwise. Okay. Act of God. This is like anything you would think of out of the Old Testament. Plagues, locusts, rivers of blood. You got it. Right? hurricanes. God bless, we live in Texas. Hurricanes. So ice on the roads, black ice on the roads, driving on icy roads. All right. Generally, the question is does this job place that employee at a greater degree of risk for this type of an injury with this type of a natural phenomenon than the ordinary public? All right. Let's see how that shakes out. All right. We all walk out of our building tonight, or wherever our respective buildings are. We're all together. We all walk out of here, and we get struck by lightning as a group, like chain lightning. Everybody hits everybody, right? Okay. Thing is, all we are is just human beings walking in the area, right? We get hit by lightning. That is the affirmative defensive act of God would prevent all of us from being all of you from being compensable. Now I would be compensable as an attorney. I'm waiting for the why. It's okay. You can tell me why. Why would the attorney be liable for being struck by lightning?
Well, because you were with your clients walking out of the building.
But
Right?
you were further in your job. You were further in your job as an adjuster, getting trained up. The thing is,
Right.
if you're not compensable because of the act of God, why would the attorney be? Why would the attorney be liable? I mean, why would the carrier be liable for the attorney claim?
Because God knows me to be. No, I'm kidding.
That's exactly the right. You know what? You're the first guy to actually say the right answer. That's right. Because dude, being an attorney puts us at a greater degree of risk from being struck by lightning than anybody else. Because God hates us. We're attorneys, right? so look, so, yeah, that's the right answer.
Wow.
So no, that's of course we'd not be compensable. But like think about it like this: like the farmer in his tractor getting the harvest in, right? And there's lightning on the thing, and he has to go over the hill, and the lightning strikes the tractor, but he can't stop getting the harvesting because he's it's a time sensitive thing. So yeah, like that guy is probably a greater degree of risk than the ordinary public for being struck by lightning, right? Because of his job. Or how about the high wire telephone repairman who's up on the heights fixing the phone repair during the storm because he's trying to get everybody's power back up, right? That guy, right? His job definitely places him at a greater degree of risk for being struck by lightning than the ordinary public. Is that fair? You kind of see how it works? It's kind of a foreseeability test. You see? All right. What about, in other words, is it inherent in the job? And what about recreational sports? Believe it or not, we actually have a lot of cases where the employer decides they want to do like the company picnic. And they say, everybody got to be there, right? The question is there a reasonable expectation of participation in that sport? For example, we see a lot of times, like in warehouses, they'll have like a basketball hoop outside, right? Or a volleyball hoop outside. At lunchtime, all the employees got to play basketball, right? But are you required to play basketball? No, everybody just does it. So when you roll your ankle playing basketball, is it compensable? No, it is not, because there's no expectation of participation, right? It's just a pickup game of basketball that you could join if you want to, but you don't have to. Now, if on the other hand, if your supervisor comes to you and says, "Hey, you better play that game. Come on, it's a team building exercise." Now it might be compensable to get injured playing basketball, right? If it's required, if there's a reasonable expectation of participation. You see how it works? All right. Horseplay. Horseplay is messing around, playing around, racing in the workplace, jumping over tables, all this stuff that I probably did this weekend. The thing is, so it's messing around, playing around, practical jokes, all sorts of stuff. Generally speaking, if the person who gets injured is a willing participant in the horseplay, then it is not compensable. In other words, if they knew they were playing around and they were intentionally if they intended to play around, then it's not compensable. So like I had a guy the other day who decided he was going to get up on a conveyor belt and like run down the conveyor belt. What? And amazingly, now this is going to come as a shock to you, but he fell and broke his leg. Now, amazingly, he got injured doing that. I couldn't believe that somebody could be injured doing that, of course, right? So whether there's a rule against it by the employer or not, that guy was playing around. He dang well knew it, right? Denied under the affirmative defense force play. See how it works? Now, we may also be able to argue personal deviation. See how that kind of works on that one? How we doing on time? Okay, we're coming up on. We said we're doing what, an hour and a half on this? Is that what we said?
Yes, 8:30.
All right, good deal.
Yes, sir.
I'll be done here in just a second then. So, ultimately, those are the basic affirmative defenses. Okay. Let me go to the next one here. Okay. Actually, I skipped one. I'm skipping one intentionally. I'm going to this one that says Tibbs rate. Okay. Let's talk about. We've been talking about compensability for a second. Let's talk about disability. By the way, this is only the kind of the tip of the iceberg, as you know, kind of beginner stuff for Texas workers' comp. But it kind of gives you an idea like how comp works, right? If you have a compensable injury, then you're and the person's missing time from work as a result of the compensable injury, then we pay disability benefits. That's how comp works. Okay. And in other states, I've heard them called y'all call them like TTD or something, or some I forget what y'all call them in other states, but in Texas we call them TIBs, temporary income benefits. Okay. And then at some point or another, you pay disability benefits up until the time they go back to work or until they get placed at maximum medical improvement by a doctor. And maximum medical improvement means as good as they're going to get. And then they get an impairment rating, a percentage of the body that was damaged, 3% or something, 5%, whatever. And then based on that percentage of impairment to the body, we pay a different kind of benefits. We're paying for damage to the body now. And those are impairment income benefits, IBs. So in Texas, we have TIBs and IBs. Not TTD, PTD, or whatever y'all call them in other states. So when you start talking about disability benefits in Texas, TIBs are disability benefits, IBs are damage to the body, like permanent damage to the body. Okay. Now there's other types of benefits after that. There's like lifetime income benefits, like when somebody's like has a Crystal Reeve kind of accident, right? And like when they, that means to get libs, you're gonna have complete and total loss of use. That doesn't mean amputation. Like they can be like arms, like their arms hanging dead in their body. That's complete loss of use, right? Both arms or both legs or an arm and a leg, pick your appendage, both eyes or imbecility. Yes, the word we still use in Texas is imbecility. And yes, that is a hotly contested issue. If you get lifetime income benefits, you can get them for the rest of your life. Okay. So we have TIBs, IBs, LIBs. There's another type of benefit called SIBs, which we're not going to talk about today, but just know it's out there. And then of course, when somebody gets injured when somebody dies as a result of their injuries, we have death benefits. Now you would think that those would be called DIBs, but they're not. And I don't know why. So it's TIBs, IBs, SIBs, LIBs, and death benefits, not DIBs. We don't call them DIBs. so there's the lingo. But I don't know why we do it. It's just, this is what people do. I don't know. So when you're figuring out the TIBs rate, okay, what we do is we as an adjuster, you're going to start paying disability benefits if you have a compensable injury and they're lost time. So you got to figure out how much you're going to pay. So you go out and you get a form from the employer called a DWC-3. It's an average a wage statement, and you look at the 13 weeks of wages before the date of injury, and during that 13 weeks of wages, that creates an average weekly wage, and based on that average weekly wage, temporary income benefits are 70% of that. So they're not getting their full wages. You see that because they're trying to encourage them to go back to work. See, kind of see how the flow works. Now, there's a bunch of rules for this. I'm not going to go through a lot of this, but I wanted to kind of use this as just a gateway to introduce you to the fact that we do pay TIBs. They're at a reduced rate. We pay them until they go back to work or they get a full duty release or until something else happens. So what are the things that might happen to stop disability, right? Remember, an employee has to prove disability. So remember, if an employee is earning more money than the average weekly wage, that means their income before their pre-injury wages, right? We don't pay disability benefits. And that first line should be a duh. Well, duh. If they're making more money from somewhere else than from us, then their average weekly wage, just supplement their income, or if they go back to work for the same employer and are making more than their average weekly wage, of course we wouldn't pay disability benefits. There's no income to replace, right? What about exhibiting an ability to work? What if they go back to work, they get injured on the job, they get a modified duty release from a doctor, they go back to work with the doctor, the doctor says, go on back to work with modified duty restrictions. They go back to work and they continue working. They're at a light duty job or a full duty job, depending on what the restrictions are. And then they change over to another chiropractor, a new chiropractor, and he takes them completely off work, like 6 months into the claim, after they've been working for like 6 months. Is that credible? Suddenly they can't work at all? Really? Why? You as an adjuster need to be able to be the one to say, why are you taking this guy off work 6 months from now? He's shown an ability to do the job and earn his pre-injury wages. What changed? And then, and by the way, the chiropractors will come up with all sorts of crazy stuff. Well, we did an MRI, and it showed he has a disc herniation. An MRI is a picture, dude. You think it steals his soul? What changed it? What changed about taking an MRI? Taking an MRI doesn't change anything. The guy was able to do it before the MRI. He's able to do it afterwards. I get my picture taken. That doesn't change my functional abilities. Think about that for a second, right? I mean, that's common sense if you just stop and think about it. What about a full duty release from another doctor? Like his treating doctor has him off work, or modified duty. And then another doctor, like they go see an orthopedist, and the orthopedist gives him a full duty release. Does that not create a fact question about whether we should be paying disability or not? In that case, I'd say we challenge disability and let the judge decide. You see kind of how it works? What about incarceration? There's an appeals panel case. Yeah, AP02, that's a 2002 appeals panel case. That's what that means. The 2002, and that's the 3000 one from 2002 or whatever. So, so in that case, if they go in the pokey, no more benefits. They're now guests of the state. We don't pay benefits while they're in jail. Resignation or termination. You know, they're working their job, or they're working light duty, or they have a full duty release. They're working full duty, and then suddenly they quit. They quit their job. Walk in. Thanks for the opportunity. I'm going elsewhere, or I'm just no longer going to work. Or I'm going to go to Europe and discover myself or something. Right? What? Well, the question is the first question would be what about so full duty resignation? Well, they had a full duty release. Of course, look at the example 2 pieces up, two lines up. He has a full duty release. Of course, we're not going to pay disability benefits. What if whether he's terminated or resigned? What about light duty? If he's working light duty and he resigns, well, he voluntarily chose to quit the job. So that's why we're not paying the benefits, right? Because he quit the job. He voluntarily chose to quit. But what if he's working light duty and he gets terminated, even for something like bad, like stealing money, embezzlement, something pretty bad, right? So he gets terminated for something like that. That's that's one that may end up with a fight on our hands on that case. So also like work available within the restrictions. So if there's work available within restrictions, like, they give him like a, 60-pound lifting restrictions and he's an adjuster. Guess what? You can do your job with 60-pound lifting restrictions as an adjuster. That's your job fits within that restriction. That's your regular job. You can do that job. Okay. I think that kind of covers some of the basic stuff in the beginning here. Do you guys have any questions for me at this point? I mean, I know we covered a lot of ground here. I was trying to give you all like the substantive law, so you have actually have something to work with. Anything in particular that you want to talk about, that you want to ask about? Throw it out there. You got me.
No, I thought this was excellent information, man, especially in bros, hoes, and dibs, man.
Yeah. And I mean, and realistically, guys, as an adjuster, adjusters, it's a pretty cool gig with workers' comp, because you guys are really getting the evidence. You gather the evidence and you make the decisions. And that's what the best part is that as an adjuster in comp, I mean, you really are the one making the decision and standing by your decision. And if they've got better information, they give it to you, and you can change your mind and do whatever you got to do based on it. But it is really, I mean, you really are like the boss. I mean, and despite what you may think, when you talk to your attorneys, I mean, technically you're my boss when you hire me on a case. So, I am just your advisor. Now, granted, I will sometimes come to you and say, I strongly advise you do this. You're not going to do something crazy because otherwise you'll get fined. But but most of the time I'm like, a lot of times I come and I say, okay, well, we're rolling the dice. We can try it like this. We can do this thing, or we can do this thing. I think that probably option 1 is the better option. But hey, you're the boss. Tell me what to do, and we'll rise and fall, go on down the road and see what happens. Right. So I mean, it's a pretty cool gig when you're doing it in comp. So, and by the way, yes, every TPA that I know is hiring right now adjusters in Texas workers' compensation. So they are hiring like crazy.
You say
so,
every TPA? You say who?
Yeah, every third-party administrator I know of is hiring. So keep that in mind. So if you're interested in being a comp adjuster, you know, especially with some of the lingo you've learned today. You know what I mean? Kind of go out there and give it a shot. I mean, but I do know that a lot of the TPAs that I've seen are all hiring. A lot of ops managers have been coming to me asking me for comp adjusters. You know, obviously they would like it if you had some training in it, but at this point, I think that a lot of them are getting kind of desperate. They might actually give you training on it, train you up from the beginning.
If you
So
would just
keep that in
throw
mind.
some names out there, just I mean, just
Well, throw some names out. Well, I'll tell you, listen, the biggest TPAs, I'll tell you right now, the biggest TPAs in Texas right now, in Texas comp are going to be like Gallagher Bassett, Sedgwick, Corvell. You can go straight to Zurich American, they hire straight. The Hartford, Liberty, Broadspire. Let me see who else is big. I'm trying to think. CCMSI, it's another one. So I mean, yeah, there's the things you get some of those. Those are all big TPAs that do comp in Texas that I know of. Texas Mutual. You know, I mean, the thing is, yeah, there are literally if you I don't know, I don't really know where they go to hire adjusters. I don't know like what websites they use, but if you go to them, I'm sure that they will you ask and say, hey, how do I get hired as a comp adjuster? I'm interested. What do I need to do? Show me where to sign. They'll give you a direction.
just call them, email them. Yeah.
So Jeremy, before you get off or before we end this, can you go over the CE credits that everyone will
yeah.
get? Can you just go over what needs to be done?
Absolutely.
And then also, I'm like Cecil on them names. I tried to help him write everything down, but definitely, you know, if you can also just touch on briefly what these particular third-party administrators are looking for in terms of, you know, what type of individual are they looking for when it comes to hiring someone who is interested in working in workers' comp? If you can touch on that just briefly.
Yeah, sure. You know, well, first and foremost, as far as this credit goes, this will give you an hour and a half of continuing education credit under your Texas license for Texas, right? So if you already have a Texas license, you get an hour and a half of credit for this. I need to make sure that, and tomorrow I've given you the sign-up sheet, but I need your name, your address, where it is tied to your license, wherever your license is tied to, right? Don't give me some crazy address not tied to your license. And then give me your license number. If you don't know your license number, you might not have a Texas license. So you need to know, you can give me that information. Get that back to me. Go through tomorrow. I think tomorrow you have the list, I think, right? Just give me the list of everybody's name, number, name, address, and license number. Go and put your phone number on there too, just in case, because sometimes I get a situation where like I can't find your license number. Or the other thing is when you put your name down as if it's on your license. If you have your maiden name on there or an old married name on there, the thing is the name has got to match the license number. Keep that in mind. Okay. These are issues I run into all the time, putting them down. The as far as the and then by the way, I think also tomorrow I think I also sent you over the review sheet. There's like a little like kind of like just a review, you know, give me a review. It's cool. You can say good, bad, whatever. I'm good with it. But I just need it done because that helps the licensing authority know that people were really there. Okay, cool. As far as what TPAs look for, honestly, I've never hired an adjuster, so they hire me. But I do know that experience is a plus. I do know that if you have experience adjusting other lines, that a lot of times they will train you up on comp. I know that a lot of times you just have to apply, and if you apply through their site, a lot of them have little training programs that'll train up adjusters on comp. A lot of times they drag me in to train you. so it's I know the kind of person they're going to want. They generally want detail-oriented people. One of the things that is really tight and important for adjusters is you need to be diligent with your documentation. Carriers don't like sloppy documentation. By the way, that also means your lawyers don't like sloppy documentation. Because when I got to explain what happened later on, like a year down the road, I want to be able to tell what happened, right? Why did you terminate the benefits, right? Yeah, the thing is, I know that it's pretty important to be able to go through the mail pretty quick, because you get a lot of mail, you get a lot of bill processing. So they want detail-oriented people. I know that. I would say the best adjusters that I tend to run into, believe it or not, I see some adjusters who are very experienced, but I would personally consider them not to be strong adjusters because they're sloppy and they don't respond to emails, and if they're not responding to emails from their attorney, that means they're not responding to emails from anyone. So because I'm the one protecting your license, right? So the thing is, and those are the same people that get complaints from their insureds, the employers, saying, hey, they're not responding to me, right? They're not calling me back. I'm sending an email and I'm not getting a response for 7 days, things like that. So I will say that one of the good things about comp adjusting is it's great job security. People are always looking for, and the more experience you get, the more experience you get, the more in demand you are, and the more money you can request. You start off, a lot of times you'll start off as if you have no experience, a lot of times you'll start off as like a file clerk, and you work your way up to, or maybe like a CE1, which is like a no loss time adjuster, which means all those cases that come in where they're just like, you're taking care of 1 or 2 medical bills. Keep in mind, if that's the case, you still got to apply this rule about what's compensable or not, because there's nothing worse than having a no loss time adjuster, newbie adjuster, take a case, let that 60-day deadline pass for what compensability, and then it gets to me and I'm like, oh my gosh, we need to deny compensability. What day did you get this? Oh, we got it 75 days ago. Oh, yikes. You know what I mean? Because you're just processing paperwork and you're not thinking about really adjusting, right? It's applying the law to the facts, because even as a no loss time adjuster, you still need to do that. And that's the kind of stuff that will hack off employers at you too, by the way, who are your clients, by the way. So, yeah, I don't know, but I would definitely say, if you already have a license, that's awesome. If you don't have a license for Texas, a Texas license, get one. That's obviously a necessity to be hired. Some of them, I think, if they're desperate enough for people, they might actually hire you without the license, put you through the training program, and actually get you the license. So I've heard over the last 6 or 8 months, I've heard a lot of talk that people are really, really looking. So just really, really looking. So it's a good field to go into, and right now we're seeing a lot of adjusters who have been doing it for 40 years. They're like retiring, and there's no new blood to replace them. That's what you want. You want to be the new blood coming in, right?
Yeah.
So
actually, Ms. Mike told us the same thing.
Yes, we do want to be that, but they asking for 5 years.
5 years? They're asking for 5 years of experience.
Yeah.
Man, I think you need. Yeah, you go look again.
At least 3 to 5. At least 3 to 5.
Really?
Yes.
Really? Because I'll tell you what. I'll keep my ears open for people who are starting new programs and stuff.
Well, if you know anybody at Buc-ee's, let me know.
Buc-ee's? I represent Buc-ee's.
Oh, well, see, there we go. Now we're gonna talk real.
I've been checking out Buc-ee's.
I'm the competitor for Buc-ee's. Yes.
Oh,
yes. Yeah. No, seriously.
They run their stuff through strategic comp. Yeah.
Yes. Well, they had a position in Pearland. So yes.
Yeah.
Mm-hmm.
Oh yeah.
Okay.
Good stuff. Well, so yeah. Oh, listen. And I guess one other thing is, one thing I didn't give y'all yet is my cell phone number. Right. I will give you my cell phone number. So if you have questions about comp, you want to talk about it, you say, how does this work? How does that work? Feel free to call me on the cell phone. I'm a traveling attorney. I travel the state of Texas. I think between now and the new year, I've got 14, 15 days out of town on airplanes. So yeah. So the thing is, so call me on the cell phone. That number that's on the front of the thing, that's my office number. That's a landline. My cell phone is, tell me when you're ready. Here you go. My cell phone is, that's my office number. That'll just get you to my receptionist. But you really want to get directly to me. My cell phone is 214-492-3933. And my name again, if you didn't get that, is Jeremy Lunn, L-U-N-N. And so, yeah, so if you want to, and I get adjusters calling me, especially new adjusters. I get new adjusters who, I'll tell you right now, one of the things about new adjusters that I see happen a lot is they don't want to look like they don't know what they're doing. So they don't call their attorney. And that's a big mistake. I have some adjusters who call me 2 and 3 times a day. And I'm talking, I have senior adjusters who've been doing this for longer than I've been doing it. I've been doing it for over 20 years. And they will call me almost every day to say, hey, I want to just talk about this. Because if you're really adjusting, if you're really slinging the hash, if you know what I'm saying, right? You're going to be talking to your attorney because you're going to be cutting it close to the line every time. You're going to be like, okay, this is where the line is, but if there's one thing you don't know, if there's one thing about law, people think law is black and white. It is not black and white. It is very, very gray. So the thing is, so there's a lot of blurred lines in there. And so people call all the time. And I mean, even me, I'll tell you right now, even I will turn around to the guy, the different attorneys that I have 10 attorneys working for me. And I turn to them all the time, walk down the hallway and say, so I got a case for such and such happened. What do you think? And I don't want them to know what my opinion is. I want to know what their opinion is, because then I can see what a judge will probably think. You know, because sometimes we get so wrapped up in our own head over our own investigations, we don't bounce it off other people when we should. You know?
Absolutely. Yeah.
Cool.
Awesome. Appreciate you, Jeremy, brother. That was good, man.
All right. Well, cool. Well, yeah, definitely. Well, thank you guys for having me. And I figured, hopefully, just like I said, tomorrow, as soon as you give me that list, I can give everybody their credit. So.
Yes. So I did put in the chat for everyone to send me their email address. It's going to be forwarded to Cecil, and then he will be sending out the paperwork. Please make sure to include your name, your address, your phone number, your name as it appears on your license when you're filling out the form, and then also make sure to complete the survey so that we know we were actual human bodies at the class. I'm sorry, I'm looking at 2 different screens, but we'll know that we are. There was human bodies in the class. So please make sure you get all of those things completed when you turn it back in so that we can get you full credit for this course, because this was awesome. Thank you so much. I appreciate it. I'm excited.
You're right.
So
yeah. And I think I got to start a question about how much is the start pay? I don't know. I mean, I kind of know what some of my adjusters make, but I'll tell you right now, before somebody asks me how much it is, I would Google that rather than ask me. I'm really not your best source for that. Plus, I can't, I technically also work for the insurance companies too, so I can't negotiate both ways.
So we actually had a workers' comp adjuster on previously, and she said she's been doing it for a while, and she's 6 figures. So.
6 figures.
Yeah.
Wow. Yeah, she's high up there then. Yeah, she's high up there for 6 figures. Yeah, I don't know really where people cap out, because I hear different companies cap out at different places, but yeah, it's not. I mean, it's certainly better than the school teacher, that's for sure.
That's true. That is true. Well, thank you so much, Jeremy. It has definitely been a pleasure, and that's all. Like Cecil said, that's all.
Thank you for having me. Y'all have a good one. Okay, have a good one, y'all.
Thank you.
Thank you.
Yeah.
Good night.
Thank you.
Good night.
Good night. All right, Tamar, so I'll have the
Tamara,
email.
Yes.
It's OJ girl.
Hey, OJ.
How are you tonight?
I'm fabulous. Thank you for coming. I appreciate it.
No problemo. I'm gonna go ahead and send you that deal on chat.
Okay. Cool beans.
Hey,
Thank you for coming.
this is Mary.
Hey, Mary. Thank you for coming. I appreciate it. Oh, thank y'all. I appreciate it.
Thanks for having. Thank you. Cecil, thank you.
All right. I'm gonna be putting in.
All right, Cecil, I'm sending you over these email addresses now. The ones that I got off the chat.
Yep. And then I sent you the ones that were sent directly to me.
So I got all the ones that's in the chat so far. I'll be sending those over to you.
Okay, I just got one more. Let me add that to the list real quick. Yeah, right on time. No. And continued credits rule. Okay. Yeah, so those are all the ones that I received directly. All the rest of them were sent to everybody, so you got those.
I'm about to send it to you now.
Cool.
Is that it?
That's it. Thank y'all for coming out. God bless you. Good night.
Good night.
Thank y'all so much.
No problem at all. We'll see y'all next week.
Okay, bye.
Bye. Okay, see, so I'm waiting to see if anybody else put theirs in there. I'm gonna go ahead and press send and send these over to you.
I'm trying to send you mine now.
Okay, no worries.
So how's your day today, Taylor?
Oh, it was good. We went to Beaumont today. We went down for a service. My husband has a client that's down there, and so he's a bishop down there. So we went down and had church with him today. It was really good.
What was the message today?
Dude, church was so good. He never got to a message. I could tell you the scripture, but like he just, man, we got there. It was just on 20. I was like, man, y'all wasn't playing today. Yeah. So yeah, but it was good.
Did you get it, Tamara?
Yes, I got all your information. Yeah, I'm gonna just put all of your information on the thing, but you still have to fill out for the survey. You'll still have to fill out the information. So just send me your email address, OJ.
I will do that, dear.
Okay, because you'll still have to fill out.
If you look on there, I send my email. I send it to everybody. When I send on the first chat on the chat deal, but I'll send it to you.
Which one is yours? Which one is yours?
It'll be INS.
Oh, okay. INS Claims Adjuster 64.
Yes, ma'am.
Oh, okay. Then I got you. Okay, I'm gonna put yours up there all together. We'll get it sent to you. Thank you, sir.
All right, dear. Well, have a
Good
good
hear
one.
from you. You too.
So I think that's everybody.
All right, see, so some of these, I'm trying to. Is that it? I think that's it. I think that's everybody.
Okay. All right. Cool beans. I am typing up that email to get it all sent out with the documentation right.
Yeah. Okay, I'm about to send it over to you now with all the names. I don't know who. Oh, Miss Ronika and Juster B still on there. But I'm gonna send this over to you right now, and then you can just, attach. Hold on, do it this way. Make it where all you gotta do is just copy them and paste them.
I like that idea.
This is other ways. Make sure I get it. Oh, good. You have any more?
No, ma'am. Miss Renika was the last one.
Okay. All right. Press and send. And once I get it, once you get any back, do you want to do the list or you want me to do the list?
If you could.
Because they're gonna reply back to you, right?
Oh yeah, I guess I gotta do the list then. Or I just copy you on the email.
Okay, there we go. That way, yeah. All right, sir.
Cool beans. Thank you
Have a
very
good
much,
one.
ma'am.
Good night, everybody.
All right.